Good morning, committee. We'll open the Fed and State Committee hearings this morning. Good morning. First on the agenda, I'd like to welcome our newest member, Senator Ron Reichman Sr. Thank you for being here, and he comes with a lot of experience. I heard he's house trained. Oh. Well, welcome. We appreciate you being here today. We are going to open the hearing today on House Bill 2066, which is expanding the military spouse and service members expedited license law to all applicants who have their established intent to establish a residency in Kansas. First of all, we'll have a staff briefing. Before we do that, I want to, we do have a lot of people that want to speak today. And I want to kind of put a ground rule out. Because of the number of people, we have 2 minutes. We've got your testimony, we've got your written testimony. So those that are testifying, 2 minutes. I'm sorry to have to do that. We're trying to get through this because if we get to us today, we will be working the bill tomorrow. So we do have a bill introduction.
Thank you, Mr. Chairman. My RS number 21 RS 1671, Mr. Chairman, and it's a Firearms Safety Act legislation.
Thank you. Is there any comment? Is there any objection to introducing this bill? Seeing none, the bill will be introduced. Thank you. So we will open the hearing on House Bill 2066. And Jason, do you have a briefing for us?
Yes, Mr. Chairman, members of the committee, you should have received in your packet a memo from our office summarizing House Bill 2066. This bill amends one statute, 48-3406. Currently, the statute provides an expedited process to allow military service members and their spouses to obtain an occupational credential in the state of Kansas. This would be a license, certificate, or a registration from a licensing body that is necessary to perform a certain occupation that is regulated by that licensing body. So in the interest of time, I'm just going to refer to them as an occupational credential in explaining the bill. The bill 2066 expands the statute both in terms of who would be eligible for this expedited process and the means by which an occupational credential could be obtained from a licensing body. On the first part, moving into the definitions, the bill adds a definition of applicant to include military service members and their spouses, but also to include any other individual who has established residency in Kansas or who intends to establish residency in Kansas. Any of these individuals would be eligible to take advantage of the statute and apply for a occupational credential from a licensing body under this statute. The bill also adds definitions for private certification and scope of practice, which I'll refer back to later when discussing how those terms are relevant under the bill. Each licensing body is required to issue an occupational credential under the statute if the applicant meets the requirements of the statute. This largely depends on whether or not the applicant holds a valid current license issued by another jurisdiction. If the applicant does hold a valid occupational credential issued by another jurisdiction, then the question becomes whether or not they're eligible under the qualifications to get a Kansas license via endorsement, reinstatement, or reciprocity. The criteria and the qualifications for getting a Kansas credential under those grounds, reinstatement, reciprocity, or endorsement, is up to each individual licensing body. So you would have to refer to the individual regulatory agency as to whether or not the individual would qualify. But if they do qualify, then the licensing body would be required to issue the Kansas credential within 15 days after receiving a complete application for military service members and their spouses, and within 45 days after receiving a complete application for all other applicants. If the applicant does not qualify via endorsement, reinstatement, or reciprocity under the criteria for the licensing body, they may still receive an occupational credential from the Kansas licensing body if they meet the requirements under subsection C2 of the bill. You can see those that start on page 2 at the bottom. I run through most of page 3. This includes holding a valid current occupational credential issued by another jurisdiction that authorizes a similar scope of practice. And this is where that new definition comes in. On page 2 in line 7, scope of practice means procedures, actions, processes, and work that a person may perform under a government-issued license, registration, or certification. So it's simply a similar scope of occupation is what we're looking at under C2 for these individuals who hold a credential issued by another jurisdiction. They also must work for at least 1 year in the occupation for which they're seeking a credential, have not committed any disqualifying acts or any other conduct that would constitute grounds for restriction, suspension, or revocation of their credential. They have to meet the proof of financial standing requirements and pay any fees that are required by the licensing board. If the applicant does satisfy all of those requirements, then the licensing body is required to issue a probationary license to the applicant based on that 45-day timeline, 15 days for military service members and spouses, 45 days for everybody else. The probationary period is basically a period to allow the licensing body to verify all the information on the complete application and that the applicant truly does qualify under the provisions of C2. The probationary period cannot last more than 6 months. If the applicant is still qualified at the end of the probationary period, then the credential is converted over into a non-probationary occupational credential. In addition to that, the bill also adds provisions in subsections E and F to allow for the issuance of an occupational credential to an applicant who does not hold a credential issued by another jurisdiction. And under subsection E, if the applicant demonstrates sufficient work experience, which is they've worked in the occupation for at least 3 of the preceding 4 years prior to submitting the application, and they're not otherwise disqualified because they haven't committed any acts that would constitute suspension, revocation of the credential, have not committed any of the disqualifying offenses, have paid the required fees, met the proof of financial standing, they meet all those requirements, then they would be issued an occupational credential by the licensing body. Similarly, under subsection F, if the applicant holds a private certification, which is defined in the bill as a voluntary program in which a private organization issues a certification to the applicant, certifying that they have met the qualifications and standards relevant to performing that occupation. If the applicant has that type of certification and has worked at least 2 years in the occupation and is in good standing with the organization and satisfies those conditions under subsection C2, then they would be issued an occupational credential as well. Subsection G substantively isn't changed from current law. It grants any of these applicants who receive an occupational credential the same rights, responsibilities as any other individual receiving such occupational credential. However, if the applicant does hold a credential issued by another jurisdiction and that credential is suspended or revoked by that other jurisdiction, then that creates an automatic suspension or revocation of their Kansas credential at the same time. The bill does add some provisions in subsection H and I regarding the issuance of a temporary permit. So this occurs if the individual has applied but does not meet all of the requirements to get the occupational credential. Then if the applicant is a military service member or spouse, the licensing body must issue them a temporary permit to provide them the necessary time to complete those additional requirements that are specified by the licensing body to obtain a Kansas occupational credential. The temporary, for all other applicants, the licensing body may issue a temporary permit to grant them the time necessary to complete those requirements. Subsection O is a new provision to the statute that authorizes licensing bodies to issue electronic credentials. These would enable the person holding the credential to display or transmit the information verifying that they hold the credential electronically. And that would satisfy any licensing body requirement that the credential be posted at their place of work or where they're performing the work. Subsections Q, R, and S govern those licensing bodies that are subject to the statute. Subsection Q expressly exempts the practice of law and the regulation of attorneys from the statute, so you cannot apply for a law license pursuant to the statute. Subsection R allows two specific agencies to deny an occupational license if they determine that the applicant's qualifications are not substantially equivalent to those established by the board. This is arguably a higher standard of equivalency than the similar scope of practice that is referenced and used earlier in the statute. So the State Board of Healing Arts and the State Board of Technical Professions, when reviewing applications for a license to practice engineering, can apply a substantially equivalent standard to the applicant's qualifications to determine whether or not to issue an occupational license. Subsection S then provides a non-exclusive list of all those licensing bodies that are subject to the statute and must comply with the different provisions of 48-3406. Finally, subsection U adds an annual reporting requirement to the statute. It directs the Director of Legislative Research to prepare and present a report on the implementation of the statute and report that to the governor and the standing committees on appropriations and commerce in both the House and the Senate. It's to include information on the number of applications received, number of credentials granted and denied, average time to complete an application and issue a credential, average time from completion of an application to issue a credential, and instances where the licensing body did not make a timely determination when determining whether to issue a credential. And that information is to be reported by the licensing bodies to the director by August 31st of each year. And the director then submits that report to the legislature and the governor by January of the following year. The bill will go into effect on July 1st of this year if it is enacted, and I'd be happy to answer any questions, Mr. Chairman.
Thank you, Jason. Are there any questions at this time? Yes, Senator Faust-Godell.
Thank you, Mr. Chairman. Thank you, Jason, for the presentation. So you mentioned that the applicant would have to have been doing this for a year. Is that a year within our state of Kansas or a year within that profession? And also, Mr. Chairman, Jason, when you mention that the report to the governor, what would be reported to the governor? Thank you, Mr. Chairman.
Yes, the work requirements are simply that they are engaged in that occupation for that specified amount of time, whether it be 1 year or 2 years or 3 years, depending on which avenue the applicant is trying to get the credential through. It's simply that they're occupied in that occupation. It doesn't have to be in Kansas because this bill contemplates people coming from outside of the state of Kansas and wanting to apply and be able to perform their occupation in an expedited manner. As to your second question on the report to the governor would be the same as the report to the legislature, and it will include that information on the number of applications received, the number of credentials granted or denied, the average time it takes to process an application and issue a credential, and any instances where that time period was delayed by the licensing body or delayed for some reason and issuing the credential.
Any other questions for the revisor? Seeing none, thank you, Jason. First proponent is Representative Chris Croft, and I would like to also, we're going to hold the questions for this until the end of the proponents. That's okay. Chris, you're up. Thank you for being here today.
Thank you, Mr. Chairman. I want to make sure I get my time started here. And thank you for that explanation. That was really good. So I can actually focus on some other things here. So as I brought this bill forward, we've been working on this now for 2 years. And as we looked at it previously, we were looking at the expansion of what's already been out there and how we developed that. We recognized at the time there were over 30,000 jobs that required licenses in our state that were open. And if you looked around the administration, everybody was trying to figure out how to bring more jobs here. This was just one of those plans to do that and how we went after doing that. But also for me, it's personal. As my wife and I, we spent 30 years going around the military. My wife had a master's degree long before me. She's actually, as you all know, she's much smarter than I am. And she had trouble every time we stopped getting a job. And she was a teacher. She did substitute teaching. She then worked in public health. She tried everything. And it was extremely difficult. I moved 16 times in the military. 30 years, 16 times. That's at least once every 2 years. If it takes you a year to go through the whole process, you almost have no time to work. And that's the thing we saw out there. Then I thought, well, maybe it's going to get better. Well, my daughter, 20 years later, husband's in the military. She's a nurse and had trouble doing it. Now, she was a specialty nurse, so I'll get some of that. But still, it's still out there. Then last year, when we put this bill together, walking the hall, one of the military members heard about this bill and came in and testified, tears in her eyes, working professional in another state, couldn't come to this state and work, even though we already had a bill in place. And so that's part of the other things here. And then this whole summer, I spent helping military members. There's one in Texas right now. His wife decided to stay because she couldn't get a license, which is part of what's in here. The board required her to do some extra things. Only the board offered that license. Only the board offered that training. They have still yet to do that training. It's been a year and a half. So she just decided she gave up, and now they're down in Texas, and he's not coming back. So these are some of the things. Also in here, former second lady and now the current first lady have picked this bill and these ideas up for military spouses. This is their number one thing they're working on for military spouses, to make sure that they can go through this. They actually want reciprocity. This bill doesn't go as far. They just want walk in and start working. I wasn't really ready to go that far. But we also have another problem here. We have BRAC coming up. And BRAC is going to be a problem. We've never experienced BRAC. The military's already taken a 5% cut. They're already a 50,000 cut in the Army. That's 2 divisions. Our division here at Fort Riley is number 9 on the training list. Number 9, you cut 2 divisions, we're out. So we have to be prepared. This bill does that. There was a Department of Defense study that was directed by the NDAA. They've done that. It recommended changing the language from a substantially equivalent to the language we did for universal. So it meets those requirements. We expanded it because the military bases also include more than just military. They also include civilian employees. This bill will cover this. This would put us by far ahead of everybody else in taking care of what the military thinks we need to do. So with that, sir, I know that my time's up. The reports at the end are to make sure that we do implementation, because that was the problem. It hasn't been implemented. There was no reporting requirement. That's why that's in there. Thank you, Mr. Chair.
Thank you very much. We'll wait for questions later. Next on the proponents, Mark Dugden with Opportunity Solutions Project. Mark, welcome.
Thank you, Senator. Thank you, Mr. Chair. This isn't the first time I've been in front of this committee on a bill like this. Senator Faust-Godot and I, along with Senator Estes, have worked on some bipartisan legislation in the past working on these issues, and so appreciate the opportunity to be here. This is another bipartisan bill. This passed with over 100 votes in the House, and I think you'll hear some positive testimony a little later from the Commerce Department about the need for this. There's going to be, with 2 minutes for everybody here, I think we'll try to be brief. I did want to point out this bill solves a problem, and this bill needs to happen. There are current, like Representative Croft said, 30,000 open jobs that require licenses today, including just down the street, 39 open equipment operator jobs at KDOT, 18 open engineering jobs at KDOT as well. And so there really is a need for this workforce. And we want people to move here, to buy cars and trucks, to buy houses that raise property values for our schools, and to provide opportunities. I did want to highlight the issue that you'll hear about a little bit with the difference between substantially equivalent and scope of practice standard that we went to in this bill. Here's the study, and we can email it to everybody, the DHS and DOD study that was put out in 2018. I'll just read a quick quote for it, and then I'll be done. The study essentially said, to effectively evaluate an applicant's license is, quote, substantially equivalent. A board generally evaluates the coursework, test scores, and applicable practicum hours of the applicant, along with previously held licenses and work experience. This, quote, this perpetuates the delays experienced by military spouses. And that is the problem we're attempting to solve with this bill. That's why we went away from that standard in last year's bill, and that's why we went to the new standard in this bill. Lastly, I'll close with, there's a lot of words in this bill. It's pretty complicated. What I would encourage you to do is to understand that that is a product of Representative Croft's tireless willingness to negotiate, to improve the bill, to put concerns and address concerns around temporary licensing, different standards. Those are all things that addressed concerns of the folks who had concerns about this bill. They're not all happy. We don't love them all. We're not for it. There are things that we had to concede in that process. But I think that's one of the reasons we got 100 votes in the House of Representatives. So with that, I'll close and look forward to questions.
Thank you very much. Next, we have Elizabeth Patton, State Director of Americans for Prosperity. Elizabeth?
Good morning. Thank you for the opportunity to testify in committee this morning. Again, my name is Elizabeth Patton. I'm the State Director for Americans for Prosperity, Kansas. I am an Army brat, actually, who watched my mom sacrifice for years when she couldn't transport her work from state to state. But now I am a Kansas resident for many years now and a mom of 4 who wants to have a state where my kids can continue to grow and thrive and stay here. And that is a big reason for why we are so supportive of this bill. I don't want to be redundant with some of the things that other conferees will say, so I'm going to try to highlight a few things on here. One is that inaction on this issue will continue to reduce opportunities in our state, and it cuts off the rungs on the economic mobility ladder for people trying to succeed when they come to our state. We know that redundant licensing barriers are especially harmful to the poor, minorities, and women. And while licensing requirements can be burdensome for all, they are particularly challenging to overcome for those experiencing financial hardships as they seek career paths and critical services for their families when they move to this state. This bill is focusing on folks who have work experience, licenses in other states. And you might hear another reference, Arizona's Governor Ducey, who talks about when they did this bill a couple of years ago, that your education doesn't evaporate when you enter the state of Arizona. So I want to be clear that this bill does not put public safety at risk. This is sound policy which helps open our state for business and makes it simpler for people to come to Kansas to succeed. Another concern you might hear about is that prospective residents might be replacing Kansas workers. Of course, the labor market doesn't work that way. There is not a fixed pool of work that new residents would compete to take. Instead, these new workers can help grow the economy in Kansas and create new job opportunities that perhaps we're not even considering now. So making it harder for those who have worked successfully and are in good standing or have a license and experience in their industry to come and work here, not to make that a streamlined process and have an opportunity to reduce red tape would be a travesty. I think am I out of time? All right, I apologize. I'd be happy to stand for questions at the appropriate time. Thank you.
Thank you very much, Elizabeth. Next, we have Andrew Wiens, Vice President of Government Relations, Wichita Regional Chamber of Commerce. Andrew, welcome.
Chairman, members of the committee, appreciate you taking the time to hear this bill today. I just want to start out by saying we support Senate Bill or House Bill 2066. It would enact occupational licensing reciprocity, as you've already heard other proponents talk about. Before we get too much further, you're aware what the bill does. I would note that in addition to the professions licensed by the Board of Healing Arts and the engineers, the Wichita Chamber would support the architects moving into subsection R, which provides for that substantially equivalent standard instead of the scope of practice standard. On the broader bill, we think this policy, applying this policy more broadly, would be beneficial to military members who can already benefit from our current statutes. But we really think there's improvements that could be made related to public awareness and enforcement of this policy, and are hopeful that this bill will help address those concerns for military members. In addition, it does apply this to anyone moving to Kansas, which we think is helpful as a workforce and development issue, as a growth issue. As you look at this bill, I would encourage you to think of your own experience in traveling to other states when we did that sort of thing. You may have consulted with a pharmacist about filling a prescription, received a manicure or haircut from a cosmetologist, had a tooth looked at by a dentist, or maybe purchased property with the help of a real estate agent. And I would just submit to you that when you did that, you probably were not wondering if the licensing regime of the state you were visiting was similar to Kansas. You trusted that they were trained professionals and would take care of you for the service that you paid for. So I think that's helpful when you think about this bill. Your skills and talents and experience don't go away when you move to Kansas. So I think I'll close by saying that this bill has the potential to help Kansas grow. It's not the only solution, but it's a good tool in the toolbox, and it can help us be the beneficiary of some talent that we bring in. So with this in mind, we'd ask the committee to report House Bill 2066 favorably for passage. Thank you, Mr. Chairman.
Thank you very much. Next, we have Travis Lowe with Kansas Society of Professional Engineers. Welcome, Travis.
Thank you, Mr. Chairman. I appreciate the opportunity to be here this morning. My name is Travis Lowe. I'm the Executive Director of the Kansas Society of Professional Engineers. Since 1910, KSB has served as the professional society representing the state's licensed professional engineers. We are here today to speak on behalf of the industry. We support substitute for House Bill 2066. And reiterate what the intent of the bill, as noted by the bill's sponsor. The main purpose of our testimony this morning, and we will be brief, is to ensure that the committee understands that over the course of this process, the Engineers Association has voiced various concerns with the bill's language and probable impacts. We are pleased to say that those concerns have been relieved in the bill before you today by the amendments that were made in the House. Thus, we do support this version of the bill, and we are not asking for further amendments. My testimony is there that details some of the merit on the language that pertains to licensed professional engineers, but do want to thank the bill sponsor. A considerable amount of time was spent over the last several months, last 2 years, in fact, working through the merits of that, and we are happy with the bill before you today. I'll yield the rest of my time, and thank you so much.
Thank you very much. Next, we have David Stauffer, Legislative and Policy Director for the Kansas Department of Commerce. David, welcome.
Thank you, Mr. Chairman, members of the committee. David Stauffer, Legislative Policy Director, Kansas Department of Commerce. I'll be brief here. So really quickly, I hope we can all agree that the military spouses piece is an obvious piece that we need to address. We need to make sure that gets done. My hope is that's kind of a slam dunk policy proposal. There's a reason why we need to be able to take care of our military spouses. We want them to be able to stay here long term. These are the type of people we want to be part of our state and see and hope that they see their home here in Kansas once they leave service and transition back to public life. But I guess the question remains, why non-military? And I think the question really becomes apparent, when you begin to look at a lot of the out-migration we're dealing with. We have a tremendous shortage in our workforce. We also talk about always, having our kids come back home. So those kids get married, they marry someone from outside of Kansas. Those people have probably spent thousands of hours working in their own craft in whatever various state that has their own regulations. It doesn't necessarily mean they're not qualified to practice here in Kansas. It just means they have followed the standard that was asked of them in that state. To simply ask folks to then reset and completely start from anew here in Kansas doesn't make any sense. So if you meet that similar scope of practice, you should be able to work here in Kansas. That's what we like most about this bill. We want to be able to get folks here see their home in Kansas, get to work, and be able to earn a living for them and their families. And that's why it's so incredibly important to get this piece done. It's not a perfect bill. We've worked with the sponsor on quite a few occasions talking through it, and we appreciate the fact that he has worked with us to be able to get a bipartisan bill here that makes the most sense for our state. So with that, I'd be happy to yield back and stand for any questions.
Thank you very much, David. That is all of the proponents that are here. We do have written support. There's 4 of those. You can see those in your packet. So we'll open it for questions for proponents at this time. Yes, Senator Longbine.
Thank you, Mr. Chairman. Let me start off by thanking Representative Croft for his work on this. I cannot express how important this is to our military installations in the state of Kansas. I represent Fort Riley. I also serve on the Governor's Military Council. There is not a meeting that I have with any member of the services that this is not a topic of discussion. It is by far their number one priority, is taking care of military families and military spouses and retirees. And so this bill is extremely important. We have had certain professions that this has been included. We had language in it that allowed them not to license. I will give you an example without naming names, but there's a commanding general that has appeared in front of this committee, in fact, who came from Texas a number of years ago. His wife was a school teacher with 24 years experience, was named that state's teacher of the year, could not get credentialed in Kansas. The roadblocks that have been put up for military spouses particularly need to come down if we're going to continue to have military installations in the state of Kansas. And when you look at the number of people who are serving our country, the sacrifices they are making, and the economic impact it brings to the state of Kansas, this has to happen. Thank you, Mr. Chairman.
Thank you, Senator Longbine. Yes, Senator Faust-Godot.
Thank you, Mr. Chairman. My question is for my dear friend, Representative Croft. If on the same lines as Senator Longbine, so I appreciate the concept of the legislation. And so when we talk about those military people, so in Wichita, McConnell Air Force Base, for me, and I network with some of those military members that are now going to retire, and they are going to reside in the city of Wichita, and they have looked for employment in the civilian community. So with this legislation, would it just allow for the time that that military spouse is here in Kansas? Is there a sunset, so if they leave, or is this ongoing? So what's the time limit, and what is your vision on that?
I just want to make sure, I think Mr. Chair is okay. Ma'am, just want to make sure I understand fully. You're saying if they're here, they leave and then come back? Is that the question? Or just when they retire, how does that work for them?
No, I was just including that retirement part in there and saying this helps set up employment for them after they leave in the military and retire in civilian life. But for the legislation itself, my question is, so would this legislation only apply for that individual during the time that their spouse is in the military, or let's say they do leave and come back? So is it just a certain time limit on being able to apply, or is it once they are certified here in Kansas, is that in standing ongoing, or does it end if they leave? I think
I understand. So the idea would be is again, your military spouse, let's say you retire, this bill still applies that. It doesn't, there's no restriction on that part of it as far as time. The restrictions do apply on how active have you been with a license. And I think, as was mentioned in one of them, you have been active in the last two of the last 3 years, or 3 of the last 4 years. And so there is a currency requirement in there, which you can like or not like. It's personally, I would have liked longer time window because military members go overseas and they're gone for 4 or 5 years and they come back. It's what we settled on right now, and it's the 2 to 3, 2 years within the last 3. So that is kind of the requirement. Does that answer? Thank you, sir.
Are there any further questions? Any of the conferees for proponents? Seeing none, we'll move on to the neutral. We do have 2 neutral that want to testify today. Tucker Polan with the Executive Director of the Kansas Board of Healing Arts. Tucker here? There he is. Welcome.
Mr. Chair, members of the committee, my name is Tucker Poling. I'm the Executive Director of the Kansas State Board of Healing Arts. Thank you for the opportunity to testify here today. I will be brief because I appreciate that you're on a short schedule. You have my written testimony. I won't repeat that. We license and regulate 32,000 healthcare providers from 15 different healthcare professions in Kansas. I would generally echo the testimony Mr. Stauffer gave in regard to appreciation to Representative Croft for working with us to make this bill have the tools to allow us to protect the public. That's our core statutory duty, is public protection. We think this bill in its current form has those core tools to allow us to do that. So with that, I will stand for questions at the appropriate time.
Thank you very much. Next up, we have Allie Devine with the Kansas Society of Land Surveyors. Welcome, Allie.
Good morning, Mr. Chairman and members of the committee. As you said, I'm Allie Devine with the contract lobbyist of the Kansas Society of Land Surveyors. And I just want to move through this quickly. Pages 1 and 2 explain who we are, what we do, the training, and how they solicit to get people to come into the profession. Like everybody else, they're having trouble kind of replenishing the supply of surveyors. If you go to page 3, I made a goof. I hit send too quickly, and I failed to correct line 5. All surveyors do require a license, and so in Kansas, you must have a license as you do in all 50 states. The core of my statement is in the next page and a half. We are grateful for the addition of the scope of practice definition, because we think that brings in the body of law of the underlying regulatory framework into the analysis by the licensing authority, which we think is really critical. Our number one issue is that people practicing surveying meet the requirements of Kansas law. So to that end, we have one concern, which goes to section 1I. We think that the scope of practice definition incorporates into that so that the licensing body can look at those, but when the law says that if they don't meet it, they may still have an issuance of a temporary license and only reject that if it's for public health and safety. Surveyors typically would not affect public health and safety, but if they screw up, it's going to cost somebody a lot of money and a financial problem. So we're relying on an interpretation by this attorney, who may or may not be wrong and who's probably going to be disputed by somebody, that section 1M is a catch-all that says nothing in this is contrary to the underlying scopes of practice. If we are reading that correctly, we are neutral because we think there is something for the licensing authority to look at to make sure somebody is qualified to operate. And if we're wrong, I ask you to put us in with the rest of the Board of Technical Professions and are. So with that, Mr. Chairman, thank you.
Thank you very much. That is the neutrals. We do have neutral only testimony, a written testimony from Mark Dugden with the Kansas Association of Realtors, and also Rachel Colombo with the Executive Director of Kansas Medical Society. Do we have any questions for the neutrals at this time? Committee, I don't see any. We'll move on to the opponents. First opponent is Larry Carnes with the Executive Director of the Kansas Board of Technical Professions. Larry, welcome.
Good morning, thank you. I am Larry Carnes. I'm the Executive Director of the Kansas Board of Technical Professions. We license engineers, architects, geologists, land surveyors, and landscape architects. These are highly scientific, precise, and technical professions. We are not like a lot of the other professions or occupations that are covered by this bill, and that's why we're asking for a little bit of special consideration to be allowed to use in subsection R the standard of substantially equivalent to determine whether or not someone is qualified to practice in Kansas. My board has 13 members. My board is opposed to this bill only because we're not being allowed to use the substantial equivalent standard. Beyond that, we're not opposed to the bill. We believe in expediting licensing for military and others. Proudly, I can tell you, we generally issue licenses within 2 weeks. We're not an obstructionary board. We want to make sure that we license qualified people, and we license qualified people rapidly. We license over 30,000 people. Half of those people are non-Kansas residents. You don't have to be a Kansas resident or intend to move to Kansas to be licensed by our board. Most of our professions are licensed in multiple states. Kansas architects, engineers, geologists are licensed elsewhere. They meet those states' standards. We expect the people that are licensed in other states to meet our standards to be licensed here in Kansas so that we can protect the health, safety, and property and rights of Kansans. What is important to us is that we maintain the substantial equivalent standards so we maintain the quality of the license to practice here in Kansas. Other states are different in the way they approach licensing. Some states require you to attend an accredited university. Some states don't require you to attend an accredited university. I believe there's 17 states that don't require that. KU and Kansas State are both accredited. They jump through a lot of hoops to make sure that they meet those accreditation standards and that they graduate qualified applicants. This bill would create a dual standard. One standard for people that are getting their initial license in Kansas and have to meet all of our qualifications, and another standard for people that are coming in from out of state that have lower qualifications. We need to maintain substantially equivalent standards, and that's what I've asked that we include all of the professions that my board regulates in subsection R. It's for engineers, we've been added. There isn't a significant difference between engineers and architects and geologists and these other technical, scientific, precise professions that we license. They all require graduation or from a degree or advanced degrees. They all require years of experience. They all require passing standardized tests. These are important qualifications that we need to have maintained. So therefore, I would ask that you all consider adding the Board of Technical Professions, not just for engineers, but for the other professions that we regulate. That's the request from my board. I want to make one last point. My board works very hard at what they do. We regularly evaluate credentials of people from India, China, Pakistan, Syria, Afghanistan, you name it, countries all over the world, to see if people who are holding those degrees really have the qualifications that we require in the United States and that we require in the state of Kansas to practice those professions. We obtain their transcripts from their schools they attended in these other countries, and we evaluate those. So my board's very practiced in evaluating substantially equivalent standards.
Thank you, Mr. Carter. Appreciate that. Moving on to the second one, we have Maria Katina with the AIA from HTK Architects. Good morning.
Thank you. Thank you for allowing me to speak today. My name is Maria Katina. I'm a licensed architect requesting that you amend this bill to include architecture. I am a principal at HTK Architects, a member of AIA Kansas, treasurer of AIA Topeka, a Topeka native, and a K-State graduate. Upon graduating, I was married and had 3 children. While I was pregnant with my second child, I took 5 of the 7 exams required for licensure. My personal experience with getting a license was difficult, but with balancing a family and working, but it was achievable by working hard and putting in the requirements that are necessary for licensure. This bill diminishes my hard work and effort that I sacrificed to earn a license in Kansas. Kansas has a Board of Technical Professions that already evaluates the standards required for licensure from one state to the next. This bill dangerously allows for licensure based on a lower standard than what a Kansas native, Kansas educated, and a Kansas architect is held to. My license represents my responsibility to protect the health, safety, and welfare of those who occupy buildings. This process by the Board of Technical Professions is already in place and works well for our profession. This bill should be amended just as engineers and the healing arts professionals were amended in subsection R to amend this so that we have substantial equivalency to being licensed. Thank you.
Thank you very much. Next, we have David Frye, David Frye, Executive Director of Behavioral Sciences Regulatory Board. David?
Thank you, Mr. Chairman. My name is Dave Frye with the Behavioral Sciences Regulatory Board. I'm the Executive Director of that agency, and I appreciate the opportunity to come before you. We are the agency that licenses and regulates most of the mental health professionals in the state of Kansas. We have about 13,100 licensees, and we oppose this bill because of its impact that it would have on the vulnerable citizens that receive services under the practitioners that we license. Individuals who receive services from the mental health professionals that we license could be children, victims of trauma, or individuals who are in a state of crisis, and that's why we are a public service agency that must protect these individuals and make sure that the practitioners who are providing services have been fully vetted and are responsible practitioners. We understand the original intent of the bill in terms of assisting military members, military spouses, and we appreciate that, as well as the urge to assist in individuals coming from out of state. But we believe there's some unintended consequences in the bill, and that's why we're requesting 4 changes. Those are found on page 2 of my testimony. In the bill, there's a definition in the word applicant in the bill that not only includes the military spouses, military members, and individuals who are moving to the state of Kansas to establish residency. It also includes individuals who have residency in Kansas. And we're concerned with the expedited time frame for those individuals who are currently in Kansas would create an impact to the board and make us process applications too quickly that could endanger the public protection, as we'd have to bring in additional staff for that. I've also added information in the fiscal note for this bill to allow for some additional staff in case this provision would apply to our agency. So we would ask that the definition of applicant is restricted to what we believe the intent was: the military spouses, military members, and individuals moving from out of state. The second, in terms of the definition of complete application, the bill defines this and says that if the results of a background check for criminal history are not in, the application will still be considered complete and the application would be processed. We are very concerned about this provision because we must ensure that individuals who are helping children and vulnerable populations have someone that we can ensure has the criminal history that would impact this. So we would ask that the definition be changed and not include this provision. And third, the implementation date of the bill is upon publication in the statute, publication in the statute book. However, the bill requires rules and regulations to be processed to implement these. And so with a probably July 1st, 2021 implementation date, we're concerned there wouldn't be enough time to process the rules and regulations to fully vet this safely. And then the last, given the vulnerable populations that we protect, we would ask that we also be included in section R. We have similarities to the Board of Healing Arts, and we would ask that we also be allowed to use the substantially equivalent standard versus the scope of practice standard given these populations. And I understand that there's a short period of time. You have my testimony, but I'm happy to stand for any questions.
Thank you very much, David. Next, we have Jeffrey Welford with the Executive Vice President of GLMB in Wichita. Good morning.
Good morning, Mr. Chairman and members of the committee. My name is Jeff Wyford, and I'm a licensed architect in Kansas and 8 other states through NCARB reciprocity. I am here today representing GLMB Architecture. We are a firm that can trace our roots back to 1919, starting in Wichita. Our company is comprised of 118 employee owners, of which 50 are licensed architects and associate architects. 9 are landscape architects and associates, and 7 are civil engineers and engineers in training. The exemption for engineering and lack of the same for architecture is especially troubling for our firm, who employs both architects and engineers. In no way should there be multiple standards for architectural licensure while engineers are exempt. As a company of both architects and engineers working together in a holistic manner on the same projects, there should be no difference in standards, as we are both required to sign and seal the design documents we produce to meet the health, safety, and welfare needs of the public. Sub for HB 2066 thus does not consider liability issues between architects, engineers, owners, and contractors. As an example, in a traditional project delivery method, it is the architect who holds the license, who holds the contract with the client. And it is the architect who is responsible to hire the engineering disciplines needed for the project. Thus, it is the architect who is liable for the engineers under contract. Why would a project owner want there to be lesser standards for the architect they hold responsible for the overall project than for the engineers we hire? This change in our law will upend a licensing process that has worked well for 72 years to protect people and commerce. The unintended consequences will be a less competent workforce and a liability problem for owners, architects, and contractors. I ask that the architecture profession be added to subsection R. This is the same exemption provided for engineering profession and the 14 professions licensed by the Board of Healing Arts. Thank you.
Thank you very much. Next, we have Aaron Dunn with the Kansas Society of CPAs. Aaron?
Yes, can you hear me?
Yes, we can.
Okay. Thank you, Mr. Chair, members of the committee. As mentioned, my name is Aaron Dunn. I'm a CPA. I'm a member of the Kansas Society of CPAs and a past chair of the society. I wanted to point out that members of the Kansas Society are all in favor of increasing job opportunities and workforce development here in the state of Kansas. But like the other proponents, the bill has some potential unintended consequences of licensing an unqualified individual, which could have some detrimental consequences to the credit and financial markets here in Kansas and to Kansas business owners and investors. CPAs must meet education and experience requirements, pass a uniform CPA exam, pass an ethics exam, and this will then demonstrate the competency needed in order to serve the public interest. And that's why that only CPAs can sign, audit, and attest reports. The financial integrity of these reports is relied upon by Kansas bankers to make lending decisions, Kansas investors to make investment decisions, Kansas business owners to obtain credit and insurance, other Kansas entities in the business supply and sales chains up and down, and many, many others. So there's a lot of public trust built into this work product of CPAs here in the state. And that's why the education and experience components are extremely important. Kansas does have an existing framework that uses substantial equivalency with the rest of the United States. Applicants for reciprocity are held to a uniform set of standards and criteria in order to practice important profession for the business owners and residents of Kansas. The Board of Accountancy currently has the discretion to execute its statutory authority to protect the public through this reciprocity system. And altering the board's capabilities and responsibilities will be detrimental to the board's ability to protect the public. And therefore, the Kansas Society of CPAs is respectfully requesting that the Board of Accountancy be included in subsection R of this bill. And I'll stop there. Thank you for your time. And I'm certainly willing to take questions and work with any of the proponents or any of the committee members on language that the CPAs in Kansas and the Board of Accountancy would be comfortable with. Thank you.
Thank you very much. Thank you very much. The next is also remote, and that is Michael Grogan with AIA Kansas.
Thank you, Mr. Chair. Thank you, Mr. Chairman, and the committee for taking time and allowing me to do this remote. My name is Michael Grogan. I am a licensed Kansas architect and a representative, or the president, rather, of the American Institute of Architects Kansas chapter. Additionally, I'm a professor at Kansas State University. As written, the substitute for House Bill 2066 changes the licensing process for architects in two ways. First, the bill expands the expedited licensing timeframe beyond military service members and their spouses to anyone coming from out of state who does not meet our licensing reciprocity provisions, but have substantially equivalent qualifications, or if they have this, we do not disagree with this particular part of the bill. The second substantive change is problematic in our eyes because it changes the path to licensure to be based on work experience instead of complying with qualifications pursuant to existing Kansas law. The bill requires that the Kansas Board of Technical Professions to assess out-of-state applicants using a similar scope of practice standard for architects rather than a substantial equivalency in qualifications. We believe altering the assessment process will unnecessarily upend a licensing process that has worked well for over 70 years. We rely on the state and licensing boards to protect citizens' health, safety, welfare by setting standards that can be reasonably ensure a practitioner's competency. The licensing board's current assessment serves as a safeguard for the public and the firms hiring licensed architects, ensuring a qualified, dependable workforce. The unintended consequences of altering the structure will be a less competent workforce and a liability problem for architecture firms, similar to what has been determined for engineering firms in this case. So the bill sets two standards for architects: those applying from out of state who may be assessed based on a similar scope of practice versus those within Kansas who have gone through and will continue to go through the rigorous licensing process that is in place to protect you, families, and everyone else using and occupying our designs. The scope of practice for architects and their educational requirements do vary from state to state, as Mr. Carnes pointed out. Architectural licensing requirements, like engineering licensing requirements, also vary state by state. Also in Kansas, unlicensed architects, similar to unlicensed engineers, are able to work under the supervision of a licensed architect. Thus, getting Kansans and those wishing to work in Kansas employment is not an issue in the architectural profession. In attempting to fix this process that's not really broken, doesn't seem like sound policy to our organization and profession. The bill goes beyond easing the reciprocity process and will harm current license holders. The bill allows all 14 professions licensed by the Board of Healing Arts to be assessed using substantially equivalent standard. These 14 professions include obviously medical doctors, but also include acupuncturists, contact lens distributors, and athletic trainers. Additionally, as mentioned, the House of Representatives has included the engineering profession in this provision and cited their licensing structure as rationale, a structure that is nearly identical to the architectural licensing structure.
Grogan, if we could close.
Yes. So I would respectfully request on behalf of the American Institute of Architects that you amend the substitute for House Bill 2066 to add the architecture profession to the provisions in Section 1, subsection R, pages 29 through 38. On that, I will leave it, and I thank you very much again for your time.
Thank you very much. The next opponent is Tim DeNoble he's the Dean of College of Architecture at Kansas State University.
Greetings. I hope you can hear me.
We can.
Okay, thank you, Mr. Chairman and members of the committee. So as stated, I'm Tim DeNoble. I serve as the Dean of the College of Architecture, Planning, and Design at Kansas State University. As Dean, I administer 3 departments with accredited programs in architecture, landscape architecture, interior architecture, regional and community planning, and industrial design, all of which are nationally prominent, as is the architecture program at the University of Kansas. I don't administer that one. This national prominence contributes to the fact that these programs, particularly in architecture and landscape architecture, at K-State and at KU, attract the majority of our students from out of state, and therefore are amazing in terms of their economic impact. Our accredited programs in architecture at both institutions meet strident national accreditation standards administered by the National Architecture Accrediting Board and meets the education requirement of all 55 U.S. jurisdictions. The NAB summarizes accreditation thusly. Program accreditation is evidence that a collegiate architecture program has met standards essential to produce graduates who have a solid educational foundation and are capable of leading the way in innovation, emerging technologies, and anticipating the health, safety, and welfare needs of the public. Similarly, landscape architecture is accredited by the LAAB with quite similar strident standards. This particular bill as written provides an end around to those who have met the standards of the Kansas Board of Technical Professionals and the standards of holding a degree from an accredited program, such as those administered by Kansas State University and the University of Kansas. It serves to devalue our degrees, potentially undermines the potency of our economic contribution to the state and to the health, safety, and welfare of the citizens. Please know that I support our current capacities to expedite the process for military members and their spouses. Thank you, and I'll stand for questions when appropriate.
Thank you. We also have there's 4 written opponents, And at this time, I'll open for any questions for the opponents. Does anybody have a question for the opponents? Seeing none, we will close this hearing on Senate Bill 2066. And we do have a last word from Representative Croft. I would like to have him so he could maybe give us a little better understanding what's in the bill.
Thank you, Mr. Chairman. I'll be quick. I know you're out of time. First off, I appreciate everybody talking about the effort. There was over 100 hours of stuff put in here. What I really do appreciate is the civil discourses we had going through the process. Even though you still hear some of it up here, it's important that everybody gets heard, and I appreciate that fact. Many people in this room got everything they wanted but one thing, and that was being removed completely from the bill and being totally exempt, because that was my only hard line when I started this thing. Everybody was going to be included. I actually tried to get the lawyers included too, but I lost that battle with the AG. So just so you know. As it was mentioned with one of the other committee members, BRAC is actually very important also to the Air Force. The Air Force has published a letter on this that they're going to go there. Remember in this thing, these are working professionals, people coming from other places. The majority of what you heard up here were people that have licensing in all 50 states. They're already licensed. So they can't just come here with no license and expect to get a license here. They can't come here and expect us to do a license that we don't have here. They're applying for a Kansas license. They have to be a licensed professional. So as in the CPA example, you come here without a CPA license, you don't get a CPA license. You don't even get considered under this bill. This bill does not overcome compacts that are already out there. Other means that are there, it doesn't do that. There was a comment about welfare and in there that we took the welfare out this one. The reason we did is because welfare is the most undefined term in the whole process. And until we could find that, we asked for examples, we were given property. Well, property's everything. So we couldn't come up with a definition, so we left it off. Maybe that's something later on another day to come back. But right now, this makes it clear it's about health and safety. You jeopardize health and safety, there is a pressure relief valve in this whole thing. They were talking about engineers earlier. Oh, by the way, too, when they're talking about when they don't meet the similar standard or similar scope, they also had, those are temporary license, and we wrote in there where they could give them additional training. So they can have additional training, it's a temporary permit, and then it becomes a full license after they've accomplished the training. So we tried to account for that problem. Engineers, it was talked about, you can actually be you can be an engineer performing without a PE license. So that's where some of that differences came in there and why we did that. It doesn't happen in the other ones. As far as talking about architects, since they brought it up, I will bring it up. And one other thing, I'm sorry, we had a residency comment. The problem is in Arizona, there was one case of a lawsuit, only one, and it was a resident was already there, said, hey, how come this doesn't apply to me? Well, they determined it can't apply to them. They went through the process. We're talking about one case in Arizona out of 2,500 licensing. I don't see that as that big of an issue. And if they already had it and they happen to already be here, why would we exempt them if they're here and they meet the other requirements that said the active time? As far as the fingerprinting, we went through that whole process with KBI. Everything's the timing-wise, 10 days. We don't see an issue with that, and that was already an issue we did address. Now, for an architect perspective, from what we went through, and I've met with many of them, so I'm just going to give you one example, but there was others in this that aren't architects. You come here, you have a license, yes. If the answer is no, you're out. If it's yes, do you have 1 year experience operating under that license in the state that you're in? If the answer is no, then you're out. You don't even get considered. If you're in and the qualifications are the same, you move on, you got it. If you're not the same, but you're similar scope of practice, so now what we're saying is after all of that stuff, take into account also what they did, issue them license. That was what we talked about on that technical change that we had to make. Then if it's a safety problem, I asked that yesterday and I've asked it on others. Do you view somebody not having an accredited license a safety issue? And the answer was yes. Okay, there's the pressure relief valve. The next problem comes in though, if you say, well, you don't trust the board to do that, well, and to give them the license anyways, well, then that's an issue between them and the board, not us. The final question that was, well, as an employer, you can make a determination to hire somebody. You do get to review all their stuff. And that's true, but then they become competition to the people. Those are all comments that were made out there to me. This is exactly what this bill is about, is to overcome these obstacles that people are putting in the way that don't make sense, that need to get military people back into work, their family members, and everybody else as we're trying to grow our economy. So with that, I just wanted to tell you that that's a quick rundown, and I'm not trying to poke. I figured if they're going to bring it up, I might as well bring up the whole thing so you guys are aware. Mr. Chairman, thank you very much, and committee, thank you for the time.
Thank you very much. So this will close the hearing on House Bill 2066. Tomorrow, we are scheduled to work Senate Bill 2 and Senate Bill 2066. So we'll do that at regular meeting 10:30 tomorrow. With that, thank you very much for attending today, and this meeting is adjourned.